So welcome back. So we are going to discuss on register of patents. So not much on this 67 to 72. Not many complications are there. These are very straightforward and we can do it very easily. So 67, it says register of patents and particulars to be entered therein. So register of patent contains name and address, notification of assignments or transmission of patents, license under patents, amendments, okay, extension and revocation of patents, and particulars affecting validity or proprietary of patents. Everything that is there, it is mentioned here. Sometimes tricky question comes here, means anything which is not mentioned here, they write that and say that it is to be registered in the patent, true or false. So that we need to keep notice. No notice of any trust is entered. Okay. So 67(2) says no notice of any trust, whether expressed, implied, or constructive, shall be entered in the register, and the controller shall not be affected by any such notice. So if a trust give any notice to the patent office, those things are not entered there. Okay. So sometimes this question comes: notice of trust is entered in register, true or false? My question to you: notice of trust is entered in register, true or false?
False.
Correct. So no notice of trust is entered. And register is under the control and management of the controller. So if the question is, register is under control and management of the High Court, true or false?
False.
Correct. Yeah. Number 4, controller can keep the register in any form, such as electronic media, to safeguard the register. If I say controller can keep register only as a hard copy, true or false?
False.
False.
True copy of register, true copy of the register by controller can be produced in legal proceeding as evidence. So in legal proceeding, true copy of register is not accepted as evidence. True or false? Is it false, right? Because true copy is allowed. Means if in any case in proceedings, if you get a true copy from the register regarding any details, then that will be called as evidence. If register is maintained,
what is true copy here? Is it the hard copy of what original documents, or what is the true copy?
Yeah, true copy means any details that you want. Okay, so patent office can give you the details in a sealed copy by signing, and that becomes a true copy. Okay, so if you want to confirm the address, okay, if you want to say this patent was amended or not, and then there is a record, right? All the amendments are recorded, and if they say that this is amendment was done, and they give a copy, they apply the seal and they seal the copy, and they apply the stamp, and that becomes a true copy from the register. So true copy of the register means they will give a copy. So for each and every request that is there, you need to make a separate request. So if you read section 1, rule 134, okay, request for information under section 153. So section 153 is, it says that we can make request for information, and here you have a list of documents from A to K. So all those, like, as to when a complete specification following a provisional specification has been filed, or application of patent has been deemed to be abandoned. Okay, as to when the information under section 8 was filed. So a company has filed this under section 8 or not, that also you can ask from the register, because that is get registered. When application for publication application was done under section 11, that also you can ask. If the application was withdrawn, when the application was withdrawn under section 11B, that also you can ask. When the request for examination was made, that also you can ask. When the examination report has been issued under section 12, that also you can ask. Application patent has been refused, when the patent has been granted, when the renewal fee was paid, term of the expiry, full expiry, everything, all these dates are given here. Those details you can ask, but for each detail you have to make separate application. We will read it when we read section 153. So those will be considered as a true copy of register. Okay. And if the register is maintained in electronic format, then entering the register means entering electronic media. So very common things. And 68 it says the assignment not to be valid unless in writing and duly executed. So okay, an assignment of patent or any kind of mortgage or any license or a creation of any interest in a patent needs to be documented with all terms and conditions, with rights and obligation, and duly executed. Okay, so this needs to be properly mentioned. Okay. Next is section 69, registration of assignments and transmission. Okay, etc. So if a person becomes entitled to patent by assignment or transmission of right or by operation of law, I mean, if person died and then other person becomes mortgage licensee, then that person should apply in writing for registration of title or his interest, meaning he has to apply in the patent office in writing. Okay, and what he need to do? Application to made in controller in form 16, rule 1991, and details to submitted as a true copies to the controller. So a true copy means verified copies need to be submitted. These are the license that happened or assignment has been done, I have purchased it, all those things need to be filed, and form 16 need to be submitted. And the fee is 1,600 for naturals and 8,000 for others. And for any dispute, controller will wait for high court decisions. So if there is any dispute with regard to license or assignment or transmission, or somebody says that no, he's not the actual owner by law, or I am the owner, many cases there could be any dispute. So then controller will not make those changes. He will wait for the high court for decisions. A true copy of all agreement licenses need to be filed in patent office. And for the license granted under a patent, controller takes a step. The terms of license is not disclosed to any person except under the order of High Court. So if there is a license agreement, then the terms and conditions are not made announced to public. It can be done if High Court says so. That is called kept secret. If no entry is made in patent register for any agreement, then those documents will not be accepted as proof of title in the patent by controller or High Court. So, for example, myself and my friend. My friend has a patent, and I said that I want to take a license from you, and he said, "Okay, you are my friend. Now I license you this patent, and you can use this invention. I will not file any infringement to you." And then I said, "Okay, you give me writing." So we enter some agreement, and then everything is done. But those agreements are not entered in the register. Okay, and thereafter, if there is my friend, after some time, I become very rich, a billionaire, well-known in the entire world because of the invention. And now my friend starts feeling jealous. He goes for infringement proceedings. And at that time, I produce a document saying that it was there. Then the controller will not accept and High Court will not accept because those were not duly done. Okay, so this is the implication. So therefore, whenever there is some license or agreement is there, we need to inform controller, and fee is not very high, means 1,600 and 8,000 for company that need to be done with Form 16. So therefore, if a question is asked like this, that that a client approaches to you as a patent agent and says that they have made an agreement with the patent holder. Please guide us. What are the steps needs to be done? Can anyone answer? What would be your answer? Anyone can answer. So my question is clear to you. Question is very simple. Question says that a client approaches you asking for guidance after any assignment or agreement is made with the patent holder. So as a patent agent, what are the suggestions you are going to make to him? No suggestion? You can ask that you can please go to next patent agent. I have not passed exam yet, right? Any answer from your side? Hello, are you there?
No, it's a little bit tough.
Yes.
The question is a little bit tough. I'm not getting exactly what the answer we have to give.
Yeah. So suppose I approached you saying that I have made an agreement with a patent holder. So as a patent agent, what suggestion you will give? So this is the question you will get in paper 2.
We have to advise that any assignment, transmission, etc. Should be registered, and the method of registration is we can do it on Form 16 under Rule 1991. Like that.
Correct. Very simple answer. We need to suggest, we need to advise them that please let us fill Form 16, and we need to pay the fee 1,600 or 8,000, and then true copies, all the assignment and agreement, all these copies, true copies, meaning not the original, but affidavit or something like this. The true copies need to be submitted, okay, to the controller.
Patent office. Yeah.
Correct. So
true copy of what?
Yes.
True copy of?
True copy of agreement or assignment, whatever deal that is there with you, right? So any deal that is there with you, that need to submit. Clear, right? Now? Okay.
So, sir, before submitting, the client will approach, right, sir? Then he will ask us the advice that he has already done that transfer of rights, and he want to get the same under registration in the patent office.
Right.
So that time we need to advise it. So
yes, sir.
Okay.
So depending on the question, right? If the question says that client wants to undergo assignments or agreement, what would you suggest? Then you have to tell everything. If it says they have done everything now, then you have to suggest that it Form fill 16. So anyway, you need to make reference to section 69, Form 16, fees and rule. That's all.
Yes. Okay.
If these things are
sir.
mentioned, then details will be taken care of. Okay.
Okay. Yeah.
Power of registered grantee or proprietor to deal with patent. So any person registered as grantee or proprietor of patent has rights assigned or grant license. Okay. So he can assign the rights. Okay. So subject to the provisions contained in this act related to co-ownership of patent, and the subject also to any rights vested in any other person to which notice is entered in the register, the person or persons registered as a grantee or proprietor of a patent shall have power to assign. He can assign, grant license under, and otherwise deal with the patent to give effectual receipts for any consideration for any such assignment, license or dealing. provided that any equities in respect to the patent may be enforced in like manner as in respect to any other movable property. Okay, so any equities of the patent may be enforced as in respect to any other movable property. So it is same. I mean, patent owner and this anyone assigned rights, they have the same rights. Section 71, rectification of register by appellate board. Okay. 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 So if you read the newer version.
Section 70 is not clear. What it says?
Yeah.
Section 70 is not clear. What exactly the outcome of this section 70?
Section 70 is very, it says that anyone who is a registered right, if you register as a grantee, then you have the rights like the patent owner, right? You become a patent owner. Very simple. Means all the rights that a patent owner has, right? They also have the same rights.
Okay.
And in section 71, so earlier it was only mentioned as appellate board, okay? But from June 6, 2019, okay? This is the amendment. High Court also comes in picture now. Section 71, rectification registered by appellate board. So High Court has come in picture from 6 June 2019. Therefore, because this is a new edition, you may get question on this line. Okay.
What does this rectification mean? Does it they will check the register or something like that?
Okay. No, I think wait. So before that, it was like only it was High Court was also there. Okay. But now it is appellate board. Okay. By appellate board. Okay. So if they say that High Court, then you need to go for appellate board now. So what it says, then upon application by any person, appellate board, okay, appellate board may make changes if entry is aggrieved. So by absence or omission from register of any entry made in register without sufficient cause, any wrong entry, any error or defect in the entry. So if these are the cases, you can approach the appellate board for rectification. Okay. So any changes you want to make regarding this thing, absence or omission from register of any entry. So say for example, person A and B are there, only A is there, B is not there. Okay. Entry is made in register without sufficient cause. Suppose you see the register and you see appearance of a company ABC in your patent. Then you can ask that why he is there. I want to remove his name, or any wrong entry in the register, or any error and defect entry. For anything, any kind of this, you can approach the appellate board. So earlier it was like you could have approached the High Court also. Okay. So now I think they have removed this now. Appellate board may expect the decision if needed. And noticed appellate board.
Yesterday there was one question in the WhatsApp that somebody has sent. The register of patents can be rectified by options where controller, appellate board, High Court, or Supreme Court, or all of the above. So the answer will be only
Appellate board.
Hello.
Section 71. What is the section 71? Intellectual property appellate board. Is it right, sir?
Yes.
No, is it
by appellate board?
Answer is only appellate board.
Wait, let us finish this first, then we will again discuss. Appellate board may expedite the decision if needed. Notice to appellate board is given to controller, and controller may appear for hearing if needed by the appellate board. So it is board or court. And then when appellate board gives direction for rectification register, the same is communicated to controller, who then rectifies the register. Okay. So who rectifies the register? It is the controller rectifies the register, but direction is given by whom? Appellate board.
Appellate board.
Okay. Direction is given by appellate board. So who is so in other cases if in case of revocation and others, if that time if it is under with the high court, then the high court also can give the direction, and then the controller rectifies the case. So appellate board, high court, and controller. So finally, appellate board will also give direction to the controller. High court will also give direction to the controller in case of this. But as per section 71, okay, this only reads about the rectification register of appellate board. It was earlier high court, but now it is substituted by the appellate board. So if you want to make any changes in the register regarding this 1, 2, 3, 4 cases, so actually it should be A, B, C, D. It should be A, B, C, and D. So numbering is wrong, not 1, 2, 3, 4. So 1A, 1B, 1C. So all this entry, you need not go to high court for any changes. You need to go to appellate board. So section 71 what it says that if you want to make any this kind of changes, then you can go to appellate board to make the changes happen, and then control will take effect. Okay. Another way is like if you find these things there, you can go for amendment. Okay, you can go for amendment under section. Which section?
Section 13.
13 or 57?
57.
Sorry. Found. Okay.
Correct. So if these are the cases, then you can go for amendment of amendment application and inspection or any document relating to thereof before controller. So if you want to amend those changes, means you want to change this, and again section 59, that is no amendment of application for a patent or complete specification or any documents relating thereto shall be made except by way of disclaimer, correction, or explanation. So here it is like correction. So you want to make some corrections, but you can also approach the appellate board and ask for that you want to make these changes, and then they will advise for the controller. And also, like when it is the case as section 58, amendment or specification before appellate board. So this is regard to the specifications. Okay, amendment application and specifications. So if you want to change complete specification, then you need to follow 57, 58, 59. This comes in picture. But if you just want to make changes in the register, so these are for the specification. And if the specification is correct, but the problem is only with the register. Register means as the entry is made there. Okay, means if you see that the application is correct, you file the right name, meaning first name, middle name, last name, you file right. Everything was right in the specification. But when you see in the register, you see it as a wrong. It is not correct. Okay, so that time you can approach appellate board and they can rectify the register, and they can ask controller to rectify the register. Okay, and if anything that I have filed, okay, anything that I have filed an application, and there is some changes, meaning I wrote middle name wrongly, some other name. For example, my name is Prem Prakash Pathak, but I wrote Prem Prasad Pathak by mistake. It was mistake from my side. So that is called for amendments that need to be done. And then we need to follow the section 57. Then I need to approach the controller and ask for those amendments. But I wrote Prem Prakash Pathak, but patent office were registering it there in the register. They wrote it Prem Prasad Pathak. So Prasad is wrong. I want to make changes in the register now. So my application from my side, everything is correct. I want to make changes in the register. At that time, I need to approach. Wait, where is the cursor now? Yeah. At that time, I would like to approach the appellate board and ask for these changes to be made. And then appellate board can give control direction. So I will have to follow this process. If my application is correct and there is changes in the register that need to be done, I have to follow section 71. Is it clear now? 57 and 71?
Yes, sir. Sir, how can we file with the appellate board? That separate provision will be there, no, sir, right?
Yeah, appellate board, there are different provisions are there. So I have not prepared on that for appellate boards.
Okay. Okay, sir. I will also see anything. Yeah. Okay. Okay, sir.
So move to section 72. Register to be open for inspection. So register is available for inspection. Anyone can get certified copies, sealed with patent office stamp. Okay. And fee is on request of certified copies under 72 or for certificate under section 147. Evidence of entries, documents rule 33 and one certified copies. What is charges? It is 1,000 for up to 30 pages. Rupees 30 for each extra pages for neutral person. 5,000 for 30 pages and 150 for each extra pages. Okay. Here certified copies are provided on first come first basis. Okay. First come first basis means I applied today, my friend applied yesterday, then he will get these copies before than me. But if I have some urgency for any reason, then I need to show the urgency. And if I want to show some urgency for getting certified copies within 1 week, so fee is 2,400 after 30 pages and 35 extra, and 12,000 for 30 pages for the other company, for the companies. So 5,000 becomes 12,000, 1,000 becomes 2,400. If I want to show urgency and I want it within 1 week. Okay. And for certifying office copies, printed each, fees is 800 and 4,000 for others. On request for inspection register under section 72, rule 27, inspection of published document under 11A, rule 74A, inspection document under after grant, 320 for neutral and 1,600 for others. So you just go through it, and I have just compiled them for you. Maybe some multiple choice question could be there from this section. On request information under section 153, okay, and information related to patent. So rule 134, any information related to the patent prosecution life, if you want to get, then this is the fee, 480 and 2,400. Okay. And register is prima facie evidence for any matter required or authorized. So this is the prima facie evidence for any matter of meaning if you want to prove that I am also the licensee, I had the agreement and now they are denying it. So all those things you can this register is the evidence. Document can be provided by access to computer or through electronic media. They can give access to you. Okay. So the thing up to section 72. Okay. So register to be open for inspection. So we have covered it. Now we'll cover the next section, that is on the patent office and its establishment. Okay. So any question till now?